Live from the Washington, D.C. area, it's the Inside Scoop. All the news that our viewers want to know. Now, here's the host.
Good evening, everyone. My name is Deborah Woolen, and I'm your host this evening for Inside Scoop. So on my way to the office, I heard a commercial. I was driving here, and I was listening to the radio, and I heard a commercial about an upcoming nuptials event, inviting couples who plan on planning their wedding for the year, inviting them to come out and enjoy certain vendors for flowers and rings and wedding dresses. And I thought to myself, how joyous it must be to plan a wedding and to plan spending the rest of your life with your favorite person. But then life comes with the unexpected, and that is why we have family law. So joining us this evening is Miles Franklin, the founding partner of the Law Office of Miles Franklin. Miles, thank you for joining us.
Thank you for having me, Deborah.
Absolutely. So I'm sure in your line of business, you've heard and seen all kinds of situations when it comes to family law. So before we get into that, what made you want to practice? Because family law is super expansive.
It is.
So what made you want to focus on family law?
The fact that when you look at the different areas of law and when you're first getting into the law practice, you want to strike a balance between what really makes an impact and what also makes me money. And
right?
Family law is right in it's squared in between the two, where you're never there's always going to be a family law matter. You're never having a shortage of work. There's always someone who's going to be reaching out, looking for help with custody, divorce. And that means there's always going to be business, so you're never going to go hungry. So for me, it was a natural decision trying to go out on my own as a solo practice to venture out into family law.
Yes, and so in my research in preparing for tonight's discussion, I looked up family law in general, and at least according to Virginia, family law includes adoption, child support, which we will expand on a lot more later, juvenile and domestic relations, divorce, domestic violence, guardianship and conservatorship, marriage, obviously, parenting and childcare, and senior rights. So just in your experience, I'm assuming that like child support and marriage are probably the lion's share of what you have to deal with?
I would say that's true, and I would just add probably tied with child support is child custody and visitation. Really, when you have any one of those three in that triad there, the other two are close to follow.
Wow, child custody, you said child support and visitation.
Mm-hmm. And custody, yeah.
And custody, okay, so we're gonna get into those too. So marriage, you hear, especially I think maybe in today's generation, you hear the phrase, marriage is just a piece of paper. And I've heard so many people, have you heard people say that before?
A few, yes.
Just a few, and it's true, but so is your cell phone bill. So is your car insurance, it's a contract. So marriage is a piece of paper, but there are some responsibilities along with that. And I think just some things that people might not take into consideration when it comes to marriage is like changing your name, property considerations, taxes, insurance. So I guess one of my questions for you is it easier from your perspective to just live together?
Well, there's two ways to think about that, and I think what you started off with there is absolutely correct, and a lot of people unfortunately don't take that seriously enough. It is where marriage is a contract and is one of the most, if you want to kind of get grandiose about it, sacred contracts that you can make in Virginia. The state does not take it lightly when you get married. It expects that you two are going to remain married, and if you can't take those obligations seriously, or if there's any issues with it and you need to get a divorce, this is not a state that makes divorce easy. So it's one of those things when you get into it, you need to acknowledge that and take the importance of how much of a contract it is. Second point to that, of living just as girlfriend, boyfriend, or girlfriend, girlfriend, however you want to do that way, just keep in mind there's no common law marriage in Virginia. So you two can live together for all your lives, however, you'll never get those benefits that you would get under marriage. So there's pros and cons to it that one needs to take into a lot of consideration when you're getting into that relationship.
And so explain the concept of a common law marriage. What is that?
So in certain states outside of Virginia, a common law marriage just basically means when you two adults are consenting and living together and acting as though you were married, the state's going to acknowledge that after a certain period of time. Some states say it's 7, 8, 9 years, or however long they set it statutorily per their state laws. And then afterwards, you two are husband and wife or spouse to spouse, and you receive all the same benefits you would have gotten as if you were seen under an officiant and you registered with the state. And it changes from state to state.
Gosh, that's so interesting that it's not necessarily easier just to live together. One way or another, there are responsibilities either way. And I did some research, as I mentioned before, and I saw, according to the Virginia Bar Association, it says in cases where there are agreements concerning the financial obligations to one another or the division of jointly owned property, those agreements are enforced through contract law. Mm-hmm. So even when you live together, you have to deal with a contract.
Absolutely, and I actually, I've had a few clients who were not married, just boyfriend and girlfriend, and the relationship unfortunately didn't work out, but they bought a house together. They had certain pieces of property, they bought cars together that they wanted separated, and so there's a thing in marriage where you can get a separation agreement. Same thing applies with boyfriend and girlfriend, because at the heart of it, they're both contracts.
So you're saying if you're not married, if you're not married, but you somehow enter into some sort of contractual obligation like buying a house, you can enter a separation agreement?
Absolutely. Oh. So the title of it can change. For the sake of simplicity for anyone who's reading it after, if it is ever entered to court, you would just say this is a separation agreement, but it's for an unmarried couple or something to that effect.
So, okay, so there's just so much that we can unpack here. So I think most people consider the concept of if I'm going to get married, I want to protect my assets. I want to protect my property. So let's venture into a premarital agreement or a prenuptial agreement or prenuptial. I think we mispronounce that sometimes. Forgive me if I have. but there's also a post-nuptial agreement. Mm-hmm. So let's talk a bit about that.
Right, and I call them prenups, postnups. Okay. It's easier just to save a little bit of time.
Yeah.
But right, so again, a lot of this, everything in marriage or pre-marriage or even kind of relationship, when you introduce the law aspect to it, it's a contract. And so a prenuptial is no different. A prenup is no different. You can contract to say before you two get married, any point before you two walk up to the altar or get turn in the marriage license, you can say, here are the terms of the marriage. Here is how we're treating certain property, whether we're considering it marital property, which has an impact if you ever get divorced. How do we handle certain aspects of child care? Now, certain parts of that you have to wait until you actually have children, but there's parts of the marriage that you can kind of contract out to beforehand.
Wow. So I think one interesting thing is one primary component in all of this, whether it's a prenup or a post-nup, is having these difficult conversations, right? Mm-hmm. I think there's some trepidation behind having to have this conversation with this person that you ideally want to spend a long time with, if not the rest of your life, but saying, in the event something goes wrong, this is how I want to protect myself. So in your experience, do you find yourself kind of in the middle of two people having to have a difficult conversation?
Right, and so a lot of the things, or a lot of the time, I'll have a client who will come in and say, can you talk to my wife, or can you talk to my fiance about the prenuptial agreement? Because there is this preconception that if you're getting a prenup, it's because A, you're wealthy, and B, you're suspecting you're going to get divorced at some point. And so this is kind of your safeguard, your shield against that. Thing I would say to people who are considering it or have looked into it, have thought about it, is it's not you're mistrusting the other spouse. It's insurance. And it's not even to say that the other spouse or the other fiance is a bad person or is going to be a bad person. Marriage is a tough process, and after 15, 20 years, perhaps it's not you two did anything wrong. You just maybe you drifted apart, and so divorce is the proper thing. We're not living in the 50s anymore where you can't get a divorce.
Right. And
so this is just a way to, if it does get to that point where you two do need to go your separate ways, it's not going to be the end of the world. You're not sitting in a $15,000 to $20,000 litigation between you two to sort everything out. This is a way to make things a little bit more simple. It's insurance.
Yes. And so when I was doing, again, I've done so much research for this. Can you tell my excitement for this topic? When it comes to protecting yourself, according to the U.S. News and World Report, just some reasons for creating a post-nuptial agreement is regret for not creating a prenup. And what if the spouse opens up a business, financial circumstances change, children from a prior relationship, estate planning, which we're going to get into a bit later. So all of these are reasons, like you said, to protect yourself and maybe essentially protect your spouse as well when things change.
And that's the other part they don't think about too, because litigation hurts everybody. Nobody wants to go to court. Not even us lawyers really want to go to court.
Oh, gosh.
So it's a drawn-out process, and you look at the average cost of a divorce, a contested litigation, it's anywhere from $5,000 to $20,000 up in here in Nova. So not a lot of people have $20,000 just laying around, and that's money that could be used for children. That could be money used for getting another home outside of the divorce. So it's something where you are protecting both of you, and you both can be on stable footing to go live your lives afterwards.
So you said that the average cost for a divorce in Northern Virginia can range anywhere between $5,000 and $20,000. Oh my gosh.
Yep.
So a post-nup agreement, do you think it could mitigate any of that cost?
It can mitigate all of those costs, potentially, because you look at an agreement because they follow a similar format, and so us attorneys will use similar templates for a postnuptial agreement, kind of inserting those unique details, but you're not going to get anywhere close to even probably the low end there of 5,000. And so you can save both of you a lot of time if you, well, first of all, if you had a prenup and talked about it beforehand, but let's say you already get married and now you want to talk about putting together an agreement, still save a lot of money in the end.
Gosh. So when it comes to putting a postnuptial together, do you recommend both people get a separate attorney, or can they use the same?
They can't. And so that's a really good point, because an attorney can only be linked to one client. Outside of that, you introduce, because us attorneys, despite popular belief, we are tied to ethics. We have a lot of ethical codes, and so one of those rules is that when you're doing a postnuptial agreement, you need to make sure that you're telling the other fiance, or excuse me, the spouse at that point, that, hey, look, I can give you advice, or excuse me, I can give you information. I cannot give you advice, though. You need to find your own independent counsel. And that can just mean taking that agreement and having an attorney take an hour to review it and calling it a day, but you do need to find someone else.
Wow. Okay, so we've gone through the process, right? You've got two people who have decided that things just aren't working out, and we will explore that when we come back. Please make sure you don't go anywhere as we continue our conversation with Miles Franklin talking about family law. We will discuss child support, separation, divorce, multiple partner fertility. You do not want to miss this conversation. Make sure you come right back.
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
Love is kind, love is patient.
Open road, here comes the Heffley family.
Whether it's a short trip or a long haul,
Estimated time, 47 hours.
they will beg,
You're hungry? I'm happy to provide.
they will plead.
Deep fried butter on a stick.
But whatever you do, don't wimp out.
Now you're talking.
Make them buckle up.
He can't hurt.
Remember, safety first. Cheese curls second.
Are you orange?
Eva Marie smoked 12,000 packs of cigarettes over 15 years. She quit, and now there's a new lung cancer screening that could save her life. You stopped smoking. Now start screening. No matter how much you smoked, early detection could save you. Talk to your doctor or learn more at savedbythescan.org.
we're back to the Inside Scoop. Here again, your host.
Thank you so much for joining us and coming back to Inside Scoop as I continue my conversation with Miles Franklin of the Law Office of Miles Franklin. We are talking about family law. In our previous segment, we talked about marriage and it being more than just a piece of paper and a prenuptial agreement and a postnuptial agreement. So now life turns left and we've got these two people who loved each other, but it just didn't work out. So now we're in the place of separation. And I'm sure you've seen maybe the best and the worst of folks in those types of situations, but there are different colors or different phases of separation. So let's talk a bit about that. What's the process for someone wanting to? So I imagine, before we go there, if someone wants to file for divorce in Virginia, can they immediately get divorced, or is there a separation requirement?
So it depends. There are two real main ways of getting a divorce. There's a fault-based method of divorce and a no-fault divorce. And so a no-fault will require a time waiting period depending on how long you are. It depends on whether you have children or not. If you have children, it's a year. If not, it's 6 months. There's certain fault-based forms of divorce as well. So if there's one method called cruelty, and so if it's acts of physical and perhaps mental violence as well towards one spouse, it's a year waiting period. So there are waiting periods associated with it, and a lot of the times when I get a client who comes in, they can't immediately file, and so it's a preparation to get ready to file.
Wow. So if two people are married and they want to file for divorce, if they have no children, then the waiting period essentially, or the separation period, is 6 months. If they do have children, it's 12 months. And for the case of cruelty, even if there's been physical abuse or mental abuse or any form of abuse, they still have to wait 1 year before they're separated from the person that hurt them, essentially.
Essentially, and there is kind of a workaround that the state has developed or has had for decades now, and so it's called a divorce from bed and board. So you still file a complaint and says it's a divorce from bed and board based on cruelty, and you can go through that whole process. You can determine things like custody, visitation, support, but at the end of it, you're still technically married to that spouse. On paper, you can't get remarried, you can't have your name changed until you get to that waiting period, and you can have what's called a merge. And so it's merged into a final divorce, but there is still a waiting period associated.
So you call that bed and board.
Mm-hmm.
So that means that, I'm assuming board means living in the same household?
It can. It can also be and this goes back to the earlier question about different degrees of separation. You can have the full waiting period for any kind of divorce within the same house under the same roof, so long as you two aren't sharing the same bed, you aren't performing any other kind of marital duties like cooking, cleaning. Oh. If you're treating them like a roommate, then you can still get away with saying we're living separate and apart.
Gosh, it's just the multiple facets of this is just really interesting. Okay, so divorce. So let's just say someone they've passed their 6 months or their 12 months and they're at the place of where they want to go through with a divorce. The no-fault divorce. Talk a bit about that.
It's a little bit of a misnomer because it's no fault, but it doesn't mean everything is just a 50-50 split. Unless there's an agreement, like we were talking about earlier with a separation agreement, you file on a no-fault divorce, you still need a trial date. You still need to argue in front of a judge for things like custody, visitation, support, division of property, claims to retirement. So it can still be contested, and it can still feel at the end of it like someone's blaming the other for a lot of things. So you can still introduce things of how the marriage broke down as part of it.
So one interesting point, in Virginia, is adultery a crime?
Yes, it is. It's still a crime. It's one of those crimes, though, unless you're in the military or the National Guard, as I was, you're not ever going to probably be convicted of it. Or if you're running for office, I'm sure that'll do some damage as well. But
I'm sure.
In terms of a divorce, though, that waiting period disappears when you're filing under adultery.
Wow.
The kicker to it, though, if you're looking at kind of the degrees of how difficult is it for me to prove a divorce, it's at the top. No contest. There have been cases where there have been pictures of a cheating spouse holding hands, embracing the paramour. Not enough. And so it's the court hasn't said it outright.
A picture is not enough.
Not unless it's explicit, and I'll leave it at that.
Literally 1,000 words. Pictures are worth. Gosh, so pictures aren't good enough.
Not unless they're extensive or explicit enough.
Wow.
Yeah.
Goodness. Okay, so the multiple colors of divorce. So now we're getting into custody. You mentioned that several times, being a part of this whole process. Two people, they have children, the marriage or the relationship doesn't work out, and so now we have to figure out custody. So again, when I was looking things up, it says when you need to have the court resolve your custody disputes, the judge will first evaluate what is best for the child based upon a number of factors. And there are 10 here, but 3 I found really interesting as far as something that a judge is going to look at to determine what's best for the child. And one of them, it says the propensity of each parent to actively support the child's relationship with the other parent. In your experience, have you found that to be really hard for two adults to do, to support their child maintaining a healthy relationship with their parent?
Absolutely, and it's the reason why if you look online of co-parenting apps, there's been an explosion over the last 5 or 6 years of just these different app makers finding these different ways to have parents communicate without communicating, because it is the hot button issue in a lot of custody cases where, because there's just been such a breakdown in the relationship, a lot of the times out of a divorce, it's just not possible for them to reconcile. A lot of the times, it's even just getting the dates scheduled for visitation. That's too high of a mountain for former couples, former parent or current parents to really get over.
When we were talking before, I asked, I think everyone says, okay, ideally, we'll just split everything down the middle, 50-50. How possible, how realistic is it to have like a 50-50 split when it comes to custody?
I would say very unrealistic. I can't tell you how many times I've had parents from both genders, fathers, mothers, come into my office and say, I just want this to be a 50-50 shared custody arrangement. I want this to be fair, and I think this is the best. Court does not agree. Court will often say, if there's not a number of factors that are met, someone's going to be the primary custodial parent. There's always going to be someone who's going to be the primary custodial parent because they need one for school. But they'll look at how close they are to school, how close, what the work schedules are, is it actually feasible, household information, whether both families have a house, things that would sustain a shared custody arrangement. And even if that's met, it's very unlikely that's going to be granted by the court.
Wow. Another factor is the child's reasonable preference. What is the youngest age? Like, how does a judge even begin to determine a child's reasonable preference? Are we talking about the preference of a 5-year-old? Are we talking about the preference of a moody 16-year-old? Like, how is that determined?
Well, 16, almost certainly yes. They will consider the preference, and they could even provide testimony in court. And you can provide testimony at any age, but wouldn't recommend bringing a 5-year-old to testify whether they want to go to mommy or daddy. And it's generally around 14 and up is where a court will start seriously considering what a child wants. There are what's called a guardian ad litem, and so it's an attorney for the child, not necessarily going to say exactly what the child wants, but they'll represent the best interest of the child.
Wow. One more factor that I thought was really interesting as far as what a judge is going to look at when it comes to determining the best needs for a child in when it comes to custody is any history of family abuse, child abuse, sexual abuse, or any violent acts or threats within the past 10 years. Why that limit? Why not forever or the past 20 years or since the beginning of the child's life? Why that limit?
It really has to do with how general and broad that factor is. If you look at it, it's any history of family abuse, and so that can include things such as DSS or audience might be more familiar with CPS, investigations done on a certain individual. Anyone can order in or request an investigation or report a concern, and that can lead to an investigation. A lot of times it's unfounded, and it just means that there wasn't any issue or not enough evidence at the time. Courts or the legislative-making body decided we don't want to punish potential parents or current parents necessarily who were investigated maybe 12, 13 years ago, and now they're going for another custody modification, or they're trying to get custody or visitation. And then there's also the thought of, we don't want to necessarily cut off a parent from their child for all time just because maybe they made one mistake or something like that. So it's one factor to consider, but it's not the end-all be-all.
Gosh, just from a numbers perspective, if there was an accusation when a child was 3, when the child is 14, a parent could still probably ask for custody over this child if there was an accusation of some form of abuse, because it's beyond 10 years?
They could. And the other thing to consider is, again, it's one factor. So in every case, every custody and visitation case, there's always one factor or two factors that they're the shining star in the case. And a lot of times it's education, but sometimes it is family abuse.
Gosh. Okay. So children seem to be like the long pole in the tent when it comes to this process of family law. We can't escape this conversation of family law without talking about child support. So again, I saw online that there's a statement that said inappropriate use of the justice system is causing alienation. This alienation affects the child's self-image forever and can result in extreme issues. So in your experience, have you seen kind of like the impact of child support, of maybe the function or the current function of our child support system today, just kind of having a negative impact on children?
Yes, absolutely. Because a lot of the times, and I've seen this more than a few times, parents are getting closer to an agreement. They're saying, okay, well, we can figure out a custody arrangement that works. And one parent inevitably has physical control over the child while they're figuring things out. And for whatever reason, sometimes, maybe they need the resources, or they feel like the other parent needs to be contributing more, and what informal under the table agreements they have isn't enough. And so they file with what's called the Division of Child Support and Enforcement. And they say, okay, I have physical control of the child, and I want child support ordered. And it'll be an administrative order, so it'll never go through the court unless you appeal it. But you can be slapped with an administrative support order one day, just posted to your door, and you can imagine that sours things pretty quickly, and it leads to a lot of court litigation afterwards.
So I think one thing that's interesting to point out is that you can be served with a child support order but have no contact with your child. I imagine that runs pretty, like you said, that kind of turns things pretty sour. So let's make sure we talk about that within the next segment.
Absolutely.
Okay, so please make sure you don't go anywhere as we continue our conversation with Miles Franklin as we discuss the many colors and layers of family law in Virginia. Please make sure you come right back and join us on Inside Scoop.
Okay, so we drowned the fire, stirred it, drowned it again, and now just feel if it's cold.
Yeah.
Cool.
Smokey just gave me a bear hug.
I know. I already posted it.
I got a crick in my neck, limp in my step, cramping in my muscles every time I try to flex. But I don't wanna get up. Very sad, no more love. All that I could do was remember you. You know I usually say no, but if you throw me love, I'll throw you some more.
It's a big responsibility.
Oh, it's huge. I know, it's huge.
And the salary.
Oh my god, yes.
Right?
I mean, like, I was about to move in with my parents, and right before, so this saved me.
I really believe in you, you know?
Thank you. It's nice to hear that from someone.
These are cool. Did you, what did you...
We're back to the Inside Scoop. Here again, your host.
Thank you so much for coming back and joining us on Inside Scoop as we continue our conversation with Miles Franklin as we discuss family law. So we discussed in our last segment custody and just the negative impact that can have on a family, including parents as well as the child. So for this segment, I want to dig deeper into child support. We cannot talk about child support without addressing the racial injustice or disparities, I should say, when it comes to that segment within our criminal justice system. It says that according to 2020, the total national child support debt got up to $117 billion. So for every parent in the U.S. that owes child support, that total was for 2020 was $117 billion, and that's according to the Department of Health and Human Services. And the majority of those parents that owe this amount of money come from low-income households. And 80% of the parents that owe this large chunk of money, the $117 billion, are Black men. When I read that, I was absolutely floored. And I was just thinking to myself, that doesn't match up. If we have this group of people that are low income and essentially perpetually cut off from access to certain sources of access to wealth, how is it that they owe this large sum of money? So just in your perspective, what are we missing? Like, what's the disconnect in our family law system, specifically when it comes to child support?
So there's a lot to unpack there because a lot of people don't realize support in Virginia is not necessarily so let's say you're unemployed and you have a child or you have several children and you are served with child support orders and you need to pay on a monthly basis. Even though you're unemployed, you can still be on the hook for $68. And so on a monthly basis, let's say that continues on and on, interest is accruing, we call them arrears, on the unpaid amounts. And so very quickly you can have an accrual of support payments that you're unable to pay because you don't have employment for a variety of reasons. Maybe you don't have the education to get a better employment, to be competitive in the market. And the courts, unfortunately, are very harsh in Virginia. There is no way to absolve arrears. I've had multiple clients with child support arrears who come to me and say, isn't there anything that I can do? My job, because I've had military service members come to me who say, look, I can't get a security clearance anymore. They are going to kick me out and then I won't make any money. And then, unfortunately, my response is, the court knows, and the goal is not necessarily to rehabilitate the situation. It is to punish. It is to punish, unfortunately. And so they will set an example out of people who do not pay. And unfortunately, a large amount of those people who do not pay are a certain shade of color. And it's a vicious cycle because if they're unable to pay, that money is not making its way to the children. And so at that point, you create another household that might be under-resourced. And now suddenly the child might not be able to go to school, might not be able to get the resources that children in more affluent communities are able to get. And when that child eventually grows up, maybe they aren't trained and they're also unemployed, but maybe they also have children. And so it can continue on. And that's how you get statistics of 90% plus of support arrears being from Black males, or from Black males, yeah.
Wow. I think the best analogy that I can think of is like making a cake. If we know that, for example, actually not for example, it's a fact that families are pivotal for strong communities. So if we know that a certain demographic, minority families, for hundreds of years, there was a purposeful breakdown of that family structure, we shouldn't necessarily be surprised that when it comes to having strong families and not going through divorce and just having functional families, we shouldn't be surprised that there's a struggle within that community. It's just like baking a cake. Sugar is essential for making a nice, tasty cake, but for whatever reason, if salt is substituted for sugar, you'll still have a cake, but will it be sweet? Will it be edible? So you're gonna have, there's the process to make that cake functional, to make that cake tasty, the process is going to be different. And I think, just in my opinion, that speaks to the disparity if the process for family court is based upon a cake having sugar, what do you do with a group of people that have been substituted salt for that sugar? And so I think that just what is your perspective in that, as far as just having a lack of access to resources, a lack of access to justice?
And unfortunately, on my end, it's hard. It's a hard question to answer because the legal system in Virginia doesn't really provide. There's no arrears forgiveness program like there are in other states. And if you're having things like your passport cut off, if you're having because your license can also be suspended. If you have a business even that you needed a business license, like I've had a few barbers who've had their barber's license suspended because of child support arrears. It's tough because the court is eventually going to say, you have $15,000, $20,000 in arrears, and so now we're going to lock you up for 30 days, 60 days. And then at that point, maybe you lose your employment, maybe you lose your job. And unfortunately, I don't have an answer to that. It's a legislative fix that needs to be made because currently the court doesn't have a real remedy for that.
So even if someone if they're incarcerated, child support is still accruing.
Absolutely.
And they're going to be responsible for that amount of money.
Absolutely.
But if they have a felony or if they lost their job because they had to go to jail for child support, they're not able to pay that. So then what?
Then unfortunately the arrears continue to accrue until the child, well, even after the child is 18 and becomes an adult. I've had cases where no minor children are left, but there's still $10,000, $12,000 in arrears that the father or mother, I've had it both cases, still needs to pay. And they come to me and say, is there any way to absolve it? Unfortunately not. Unfortunately not.
So what do? You have these two people, they were in a relationship, let's just say they didn't get married, but a child was produced, and they say, okay, I really don't want to go through the court system. I will pay you $500 a month because that's what I can afford. Would you recommend something like that? Or and I imagine that situation is probably more common than not. What has been your observation in those kind of personal agreements?
I would say don't do it because the legal system considers that a gift. It doesn't consider it child support. Unless there's a support order that says father or mother has to pay $500 a month, it's considered a gift. And so if you want to do that, if you have an agreement, that's great. Find a lawyer, one of you maybe split the cost for a lawyer and give them an agreed order, or just say we have agreed on $500 and they can push it through the court and it can be finalized, formalized that way. If it's something where you just say it under the table, you run the risk at any time of the other parent who has control of the child to come to the courts and say, well, now we're going to try and bring forth a support petition.
So what's the difference? So what if someone cannot afford an attorney? What about a mediator?
You can do mediation too, and that's I would say if there really are no disagreements in the terms and you just need a mediator to get a mediation agreement, you don't even really need an attorney to start a support petition. Plenty of people do it without an attorney. You can start the process there, request a mediator, or find a private mediator and have them do it prior to the next court date, and you can have it pushed through, finalized that way in a way that encompasses a support order.
So child support, like the number, that monthly amount, what goes into determining that number?
So there are guidelines, and anyone can go online, you can type in child support guidelines calculator, and a bunch of attorney sites will have free calculators for to use. It's based on your income, your gross income, so that means before taxes, how much health insurance you're paying, any other children that you might have in the household, and that's all added up into the final calculation to however much you owe. And then also it looks at what kind of arrangement that you have. So if it's a shared custody arrangement, you're going to be paying less than if one parent's the sole physical custody of the child.
You said other children in the household. So if someone has a child by someone and there's one child between them and another person, but if the other person has two other children, could that person's child support be impacted by the presence of those other two kids in the house?
Absolutely, and the way it works is you can think of it as a tax deduction. It's deducting from the child support amount for every other child obligation that you have. So I've had cases where a father has children in 3 different states, and so for Virginia, the 2 other children from the 2 other states are deducted from their support amount.
Holy moly. So we can't really talk about child support and the number of children people have without bringing up Nick Cannon. So Nick Cannon has 12 children and counting. But I want to talk about this phenomenon called multiple partner fertility. In the UK, it's actually being studied as a social issue. And multiple partner fertility is basically having children with more than one person. But it almost seems to be like a class issue, because if we think like Clint Eastwood has 7 kids, 5 different women. Rod Stewart has 8 kids with 5 different women. George Foreman, the former boxer, 12 kids, 5 different women. Kimora Lee Simmons, the fashion mogul, has 4 kids, 3 different men. So we might shake our heads and shake our fingers at these people and say, oh my gosh, how could they do that? But the truth is, when we think about Rod Stewart, George Foreman, Oscar De La Hoya, Kate Winslet, who's got 3 kids with 3 different men, we might shake our head, but it's just okay, that's their business. But when we see someone in court who might have an income of $30,000 a year and they've got 5 kids with 5 different women, the court looks at them differently. The court handles them differently. So do you think, in your opinion, the court supports a classist perspective when it comes to having children with multiple people?
I would say so, and I think more to the point, though, in case of the mothers, I've seen a couple of cases, several cases, where mom does have children from multiple different fathers, and several of those fathers or the father's mothers or their family ends up putting in petitions for custody and visitation. And unfortunately, in that case, that scenario, mom might only make $30,000. Mom might even be unemployed, but now she's facing 2, 3, 4 petitions from separate counties, from different parents, family members, and she doesn't have the funds to fight against that. So she goes what's called pro se. She represents herself, and she may find herself in a situation where she might lose 1 or 2 of her children. And for the children, thinking about their perspective, that's rough, because then now suddenly brothers, sisters in a different county, they might even be in a different state, and mom doesn't have the resources to wage another legal fight to get them back. So yes, I do think there's a divide there, where if you don't have the money to support the children, you could see the breakup of your family unit, which again would lead to the other issues we talked about earlier with support and issues with divorce and all that kind of plagues our community.
Wow. So it almost seems as if you can afford to have the children, then have the children. If you cannot afford to have the children, then don't. I think Michael Jackson has a song that says that. So when we get back, we will continue our conversation with Miles Franklin as we talk about family law. We'll finish up with multiple partner fertility and then get into elder law. You don't want to go anywhere and miss this conversation. Make sure you come right back to Inside Scoop.
I can't believe we broke old man Hennessy's window. Correction, dude. You broke. I just threw the ball. This is really bad. What are we gonna do? We? Go to the door, ask for the ball back. Are you serious? It's my ball, Myrtleback. You're so dead.
I'd run away.
Yeah, to Uruguay.
Kiss your life goodbye. Sorry.
Let's go. See you, dude. See ya. Remember me and your well. Nice one. Some friends you are.
Hi. Tell him it was an accident. And we can fix the window. Come on. I'll come with you.
Loyalty. Pass it on.
You go first.
A message from the Foundation for a Better Life.
One day these rats were playing in the woods. One in some matches and that's no good. Listen to smoke before you give it a try. Only you. Don't play with matches. Don't play with fire. Cause there's nothing very funny about fighting. Nothing very nice on a homeless mind. So if a gorgeous force is what you desire, don't play with matches. Don't play with fire. Yeah.
Only you can prevent wildfires.
Fire.
Awkward. I'm the awkward silence. You try to avoid me, then there I am again.
But an awkward silence can be a great thing.
Like Kelly here is about to demonstrate.
You haven't really been yourself lately. Are you okay?
Find out how you can help a friend with their mental health at seizetheawkward.org.
We're back to the Inside Scoop. Here again, your host.
And thank you so much for joining us again on Inside Scoop as we speak with Miles Franklin, attorney at law of the Law Office of Miles Franklin, while we talk about family law. So during our last segment, Miles, we talked about child support and just the racial disparities in that and how it affects people with low-income communities, but also child support also affects the rich and the wealthy and the celebrities, but it's looked at differently because essentially they can afford to have them. So if someone finds themselves in a situation where it's inevitable, they are in a relationship with someone, it didn't work out, but now they have to entertain the aspect of child support, what can they do? How can they be proactive to best prepare themselves?
First thing I would say is to talk. See if you can open up communication. I know it's probably a bitter pill to swallow after the breakdown of the relationship, but just reach out, try to talk to them, say, okay, I understand I need to pay child support. What is reasonable for both of us? Come with a number and say, if I was able to put this towards the child each month, would that be enough, do you think? And just see what they say. If it does turn into a situation, though, where you're pretty confident that they're not going to take any kind of number that you find reasonable, look up the child support calculator that I mentioned earlier and put in your income, put in her income, and get a reasonable expectation. I would actually say probably do that first and then go with your number. You want to have a reasonable number, but look at that number and say, okay, what am I actually looking at? Because the court is going to presume that number is correct. And so if you want to go lower, you need to have some kind of reason for it. And if you can't come up with a reason, you might want to look at your finances again because she has the authority or he has the authority as the other parent to go and request that support if they're taking care of the child. So it's something that you just need to consider. And so child support is independent of custody? It is. And that's a really good point because I've seen a lot of clients who come to me and they say, I'm paying my support all the time, but I never see my child. What's going on? And I have to tell them that the court they look at it separately. Custody and visitation. Well, really, custody is its own thing, visitation is its own thing, support is its own thing, and you need a petition for each to either change or get it started. So it kind of seems like if someone is intimidated by the whole court system that they're going to need some guidance, which essentially is the support of an attorney or a mediator. So how can they prepare themselves in that vein? I would say mediators, again, are helpful up to the point where you think you can agree to the other party. If it breaks down and you reach an impasse, a wall in the road, and you know you can't go any further, you'll want to seriously consider an attorney. You don't necessarily need to get someone who's the highest priced. There are legal services. There's legal services of Northern Virginia, actually, that provides low bono or free services, legal services, for exactly that, child support, child custody. And you can get a competent attorney. There are great people up there who can help you out with your case. Great. Okay. And at the end of the show, we're going to make sure people know how to get in contact with you when it comes to help with family law. So let's move into elder law or senior rights, which is another branch of family law. And so first, what is elder law? So elder law is encompassing the end of a life cycle. So when you're at the stage where either through medical diagnoses or through just an inability to keep up with finances, you need help. And so maybe you go to a center, you go to a nursing home, nursing care, so there's law related to making sure that your rights are upheld there, but there's also if you're incapacitated, so you can't make your own decisions, financial or otherwise, you can get what's called a guardianship or a conservatorship, and someone else can make those decisions for you. Okay, so let's talk a bit about that. What's the difference between guardianship and conservatorship? And let's just say there's an adult whose parents they see signs of dementia. When should they start the process? Is it guardianship or conservatorship, or when should they start the process of interacting with the court to protect their parent? So I would say, well, to answer the overall question, high level, what is a guardianship? Guardianship allows you to make decisions outside of finances. So where they're going to live, what kind of conditions they're going to live in, whether they go to hospice, nursing home, kind of end of life or incapacitated decisions. It's not necessarily medical now. That's separate. It can be separate anyway. But a conservatorship that handles financial decisions.
Okay. Gotcha. And so if a parent or an adult child sees that their parent is experiencing signs of dementia, how do they begin that process? Do they get an attorney? Are there medical steps? Should they consult a doctor? Do they need a doctor before they get the process going? Like, what should they do?
So you do want a medical examination from a licensed physician saying that, in my professional opinion, I believe grandma, grandpa, dad, mom is unable to make their own decisions or could use assistance and needs a guardian or a conservator, primarily a guardian, because that's where the major decisions in their life are going to come in. After you have that, or in the process of doing that, you also want to put in a petition to, it's going to be the circuit court, and so that's the second highest level of the court that most people interact with. So you want to put in a petition that says that you are going through that process, that does an accounting of everything that mom, grandma has kind of stored up there, and so that can take a while. And so I'd recommend anyone trying to do that does it as soon as they start to see signs. And for every person, that's going to be different, but the sooner the better.
Okay. Let's just say someone's, I think in Virginia, you can't drive past the age of 95. My grandmother, she'll be 97 this year. She's still quite angry about that. She can't drive. But let's just say there's someone in their 90s, very alert. They absolutely still have the ability to drive, but Virginia doesn't allow them. Is there anything that they can do to override that law?
To get a license for driving?
Yes.
They can try and put in a petition now.
Okay.
I doubt it would go through at that point.
Sorry, Grandma.
But they could try. They could try. And that does bring up a good point, because if you have someone who's reaching up in that advanced age, but they're still as spry mentally as they were when they were 20, 30, good on them. I would recommend anyone who's their child know that you're going to have a tough time getting the guardianship, because it's contested. It's presumed to be contested. And so that person, that elderly person is going to get a guardian ad litem just as a child would. And so if that GAL says, well, there's no reason for them to get a guardianship, you're going to have a hard time getting it through.
Wow. And this seems to touch on estate planning a bit. So where is the overlap in maybe elder care or elder law and estate planning?
Well, I would say you can pre-plan for elder law or elder law topics when you're very young. You can always make in your trust, or excuse me, in your will, or your advance directive, you can have someone assigned as your agent to act in your interest when you're very young. And so you can have that be maybe a family member who you trust, maybe an uncle or niece or nephew, someone down the line, so when that point of incapacity comes, or it's near that point, they can take that role and you feel comfortable about doing it. And you're not making it at a point of tension or distress.
So what do you do if there's a parent who is incapacitated or they're going through dementia and they have 3 different children and each one disagrees with how to handle mom and dad? What does that process even look like?
So if you don't have an advance directive or a guardianship or a power of attorney already developed, then that means each one of the children are going to have to put in their own petition for guardianship. And so you can do that. You can have, there are definitely cases where there's 7 children and each of them has their own petition. And so that's where you get into contested elder law litigation. I would hope, though, they'd be able to agree and come to some kind of cooperation, but it doesn't always happen.
Gosh, and so each child essentially, or each adult child would have their own attorney. Oh my gosh, have you seen something like that before?
Yeah, it was down in Fredericksburg. I think it was 12, because they weren't all children, they were nieces and nephews too. It was like 12 different petitioners, each with their own attorney. And I wasn't on the case, but I was just sitting there and the judge was just going through the signatures. It was 12 different signatures.
Just wanting control over or say over.
Right, who was going to be assigned as the guardianship, how it was going to look like in the final order. And so everyone had to sign off on it.
Oh my gosh, I'm sure that was a mess.
It was long and it was a mess.
Gosh. Okay, so we've talked about custody, we've talked about marriage, divorce. separation, child support, elder care, all of these are branches of family law. So if someone has any questions about anything that they've heard this evening, how can they get in contact with you?
Sure. Easiest way to probably do that is through my website at milesfranklinlaw.com. There's a link there that can take you to an initial consultation. Happy to talk about your matter. Do 30 minutes free, so if you want to just talk about whatever issue you have, then I'm happy to listen to that. I also have a Facebook link that should be posted on the screen here, and a Twitter account that you can also reach me at as well. So always happy to talk about family law matters.
Gosh, and is 30 minutes really long enough? Is that, in your experience, do you find that people just kind of go over, or there's going to have to be a part two to the discussion?
Sometimes. I've gotten better about kind of honing in on the issue and go into the consultation knowing that we can't solve everything at once, but if you give an idea of what you're looking for, we can cover a lot of ground pretty quickly.
Gotcha. Would you say that most of your cases are child support, divorce, marriage?
I would say most 50% are probably child support and child custody. Other 25% are divorce, and then other 25% is estate planning.
And just typically, just out of my own curiosity, how long does, like, from the moment they file a separation to divorce, what's the typical time frame?
It depends, but I would say if we're talking about just a no-fault, living separate and apart, it also depends on where you live. Because if you're in Stafford County, you can only get a trial date 4 times out of the year, compared to Fairfax, where you can get it monthly. So it could be anywhere from 4 months to a year or 2 years. It could be a long process.
Gosh, can someone live in Stafford and then file for divorce in Fairfax County?
You two, so long as you're a resident of Virginia, you can file wherever you two want, but if one party disagrees, it's usually where one of them lives. So if you both live in Stafford, one of them tries to file in Fairfax, you can transfer it back into Stafford and it'll probably be granted.
Wow, so even more reason just to make sure if you're going to go down this road, try to walk together as much as possible at the beginning.
Hopefully, because there is a way to try and streamline it, but if you two start disagreeing, just know that's where costs start piling up and that's where time gets longer and longer. Absolutely.
Like you said, that's where cost piles up and you want to save as much money as possible in this whole process. Yeah?
Absolutely.
Okay. So my favorite part of the show, you all already know, it's either or. We're going to do this rapid fire. Okay, movie or book?
Book.
Paper planner or digital planner?
Digital.
Swimming in a pool or the ocean?
Can't swim, so neither.
Okay, hanging out with kids or hanging out with older folks?
Older folks.
Okay, A Different World or Martin?
Martin.
Okay, jogging or hiking?
Jogging.
Money or love?
Money.
Thank you for watching Inside Scoop.